like to thank Mackrell International for sponsoring this program. Mackrell International is a global network of 90 independent member law firms totaling 4,500 lawyers working in 170 offices in 60 countries. Mackrell International delivers legal services to companies who need global expertise and local influence. Dr. Volker Wodianka, who is our key speaker today, is the co-chair, and I, Stephanie Sparks, am a proud member of Mackrell International's Privacy and Data Security Group. Our speaker, Dr. Volker Wodianka, is a lawyer with SKW Schwartz Law Firm in Hamburg, Germany. He specializes in data protection law and advises on complex process launches in large multi-level organizations. In international data protection, he is an expert for the implementation of the General Data Protection Regulation, as well as the requirements of cross-border data traffic. I am Stephanie Sparks. I chair my firm's data, privacy and data security and intellectual property teams. I also counsel companies on privacy laws, including the GDPR, and I help them create and implement administrative, technical, and physical safeguards for data security. Hoag Fenton is providing 1 hour of California General CLE credit for this webinar through the California State Bar. For those requesting CLE, please email us at gdpr@hoagfenton.com, and we will provide you with a CLE certificate and materials. A copy of the materials will be sent to all registrants following the webinar. This webinar is also being recorded and will be made available to registrants through May 2018. Let's go ahead and get started. Volker?
Thank you very much, Stephanie, and hello everyone, and welcome to the webinar on GDPR, wherever you may be at the moment. I think today we truly have an international webinar, a content that would apply and affect all parts of the world, and I would like to go through with you through the main requirements of the GDPR, and that you have a basic understanding on when it applies and what you should do now. The GDPR is passed by EU Parliament already in 2016, April 14, and it's a law that will become enforceable on Monday, May 25, 2018. So you might think there's still a couple of days left to prepare for this new European law, and I would like to make sure and make clear and help you together with Hoag Fenton that you're on the right track with all the measures that you need to take for preparation of GDPR. Basically, it's of course, as the title already says, a general data protection regulation, a European law, and what is also interesting to understand that it's there's no like a process of enabling this legislation to the member states. There's no transposition or any other act necessary for it being applicable in the member states of the European Union. So, and this is also a big difference from the data protection or legal environment as of today, which is derives from the European data protection framework from 1995, where as a result, and this is also a main aspect of the regulation now, the idea of having a harmonized framework, that did not really happen after this 1995 framework, and the regulation has the purpose and the idea to really have a harmonized law all over the European Union, the member states. So I think that's a very important aspect. It's applicable to all EU member states directly. So okay. Then I would like to also underline that the data protection authorities, keeping in mind that the text and everything is already published since 2016, do not see any any necessity for a so-called grace period. It will be really also enforceable, and they're going to take action. That's what the data protection authorities say from May 2018 onwards. So that is, I think, really an important aspect on the question when is it really necessary to be ready for GDPR. Just to give or name just a few of. There's a question. Yes, Stephanie, please.
Yes, there is. Can I go ahead and publish that question?
Yes, please.
Okay. Let me just go back and publish that. Question from the audience.
Okay, there's a question from the audience. Will a small U.S. law firm that has just one or two clients in the EU have to take any steps? Can that law firm assume email exchange using Gmail or Office 365 are okay? Well, in a way, it's about the territorial scope of GDPR. That is one very important aspect, of course. And the law says that as long as you offer goods or services, like directly target EU data subjects, you would fall under GDPR. So basically, for those clients that you have and target EU clients, you should follow the requirements of the GDPR. Yes.
Thank you, Volker.
Okay. Yes.
A message to the audience. I understand that some may be having audio problems. If you are, please use your phone and dial in. I put that phone number and the passcode in the attendee chat section, and mute the sound of the microphone and the speakers on your computer. Thank you.
Yeah. Thank you. What is also important, and to give also like the idea why do we have like a Mackrell webinar here, the idea of harmonizing the European data protection law remained like an idea, because still there are areas where member states can fill out like gaps of the law and have still, in addition to the GDPR and national data protection law. This is already done by many parliaments in the member states. They have time until May 2018 to create an additional data protection law. For instance, in areas that have exemptions like laws on national security, on the employment context, or also on very special clauses concerning whether you are obliged to appoint a DPO, a data protection officer, or not, which is, for instance, in my home country, in Germany, still today an obligation to have a DPO from the 10th employee that works with personal data, and will remain with GDPR as an exemption from the rule of the GDPR, where you have a higher level of data processing before you need to really adopt a DPO. So this is basically the first overall idea of GDPR, and I'm gonna go to the next slide. I mean, there are maybe you already had some conferences or took part in GDPR events where you only had slides with two numbers, 20 and 4. This is or refers to the fines of the GDPR, and gives the answer to the question, why does the GDPR matter? There are kind of very high penalties in the law, and it's important to read really precise here, because non-compliance with GDPR can go up to this is important. We should have underlined these two words, up to 20 million or 4% of annual global turnover or revenues for failure with very basic data protection principles, with failure to obtain, for instance, a consent from individuals. There's I'm gonna explain that more in detail. It's not really a big deal, this idea of consent, but there are still areas where, for instance, in an employment context, where you need really a consent of an employee before or prior data processing, for instance, concerning the picture of an employee when you want to put it on the website. But just to give examples where really fines can harm the budget of the company quite severe, and also violating data protection authority orders is highly fined. Now the real question is, how does it look like in practice today? And there I of course can tell you, I mean, there are the data protection authorities that execute these fines. They publish annual or every 2 years their data protection authority reports, and also publish the fines, and they can vary a lot. Today, for instance, there are authorities that report in their annual reports fines between 175 euro up to 6,000 euro, but then a single fine was 350,000 euro. And these are, frankly speaking, today the exemptions in Germany, that fines can go really so high. We had some other two important cases of a supermarket chain called Lidl and another big company called Deutsche Bahn, the railway company, and they paid €1 million of a fine. But this is not really the day-to-day business. A very current example for non-compliance and how high can fines be would be, as you might know, after the decision of the European Court of Justice that the safe harbor agreement is regarded being void between EU and US. There were 3 companies in Hamburg, my hometown here, that paid 15 and up to 20,000 euro for non-compliance with this tool of transporter or international data flow. So these are the real fines today, but the real world after May 2018 could look a little bit different, and so I really recommend to take this serious. You don't need to talk about 20 million or 4% of annual global turnover, but the law really gives the authorities more tasks and more duties also to execute the law. And so I think we're going to be in a different, more serious environment next year, also concerning fines. Okay.
Volker, I have a couple of questions on that last screen.
Yes, please. Yes.
One is about Brexit.
Okay.
What about Great Britain prior to and following Brexit? Will the GDPR be enforced?
Well, you know that there are a lot of discussions about Brexit, and today is, and also in May 2018, so far as I know, quite formally, there's not going to be a Brexit at that date, but I think we talk about March 2019 or so, where the process of the UK leaving the EU would be really would be the case. So, and then the question is whether the UK would be regarded as a so-called third country. You know that you're really in a good situation when you want to process personal data inside the EU, and UK could be out of the EU and be regarded as a so-called third country. When you then need also other tools like EU standard contractual clauses and BCRs or so. Recently, in August 2017, there has been a new data protection bill being published in the UK. That, as far as you can tell that today, is really open to comply with GDPR. And in a so-called Queen's Speech that was published the last weeks, it was also said that Britain prepares for GDPR. So we expect that at least after then March 2019, or when Brexit is already done, there will be a so-called adequacy decision. That's a decision by the European Commission, where you check the local law, in this case the data protection bill of the UK, and decide whether it's like in line with the European data protection law, and that would be like the expectation. So we expect it to be like to receive an adequacy decision.
Second question.
Yeah, another question. Mm-hmm.
Yes. How will the GDPR be enforced if a company does not have a physical presence in the EU?
Basically, the enforcement of the regulation is carried out by national authorities, the data protection authorities. They have the right to enforce the law, and they would use all applicable rights to also enforce judge order in other countries and use international agreements and so forth. The other aspect is there's a special role called EU representative, which is regulated in Article 27 of the GDPR. So there might be an obligation for those companies that, as I said, target EU data subjects with goods or services to have a so-called EU representative in the EU, who is not only a contact person, but as today we interpret the law, would be also obliged to give information to the data protection authority and kind of cooperate with this authority. And if you do not have that representative, it's also fine, no? Because it's an obligation. So this is a very interesting role in Europe, then, this representative. And they try to go over those kind of roles and execute it.
Thank you.
So should we go on? I think
yes.
Talk about principles. Here you have two colors: the core EU data protection principles, plus then GDPR. I mean, it's of course also. Or me as a German data protection lawyer, we already have quite a strong data protection law since ever, and the basic principles of the EU data protection law remain the same. That's one important message to all the EU member states, that it's not a totally new law, but I mean, you have the principles of fairness, of lawfulness, and transparency. You always need like a legal basis for every data processing that you plan and do, and then you have purpose limitation, data minimization, but the quality changes kind of, because these principles are in the reading of the GDPR also principles that and requirements that if you do fail to comply with these requirements, you can be fined. And I think this is the different quality of principle like data minimization. Yeah, for instance, you minimize data when you do not use the full data, like saying like first name, last name of an employee, but use a pseudonym like the employment number, and replace the number, replace the name with a number. This is, for instance, a very easy way to do data minimization. And others are storage minimization, security, integrity, and confidentiality. What I would like to underline here is that GDPR gives a lot more possibilities to find a common sense with your information security organization. CISO, Chief Information Security Officer, is more aware of principles like integrity and security as a normal DPO is. And I think there are good ways to work together with the roles and organizations that you already have that look for the security of any other data rather than personal data, which is the main aspect of data protection law. Which is new then on the right side, or additional principles, is the accountability principle. This is a very strong principle because it more or less says that you should be able to present compliance with the law at any time. And everybody who is aware of the structure and way audits work knows that it's about really giving proof by presenting documents, presenting guidelines. It's about presenting training materials, and agreements, everything that you would like to show an auditor in order to convince those people that you're in line with the law and that you did the necessary thing. And this is maybe another principle that I didn't put here on the slide, but it's of course all about adequacy and finding like the right level of data protection for your organization, because it applies to any kind of sector, and it's a law that is for all companies, but not all companies are the same. Which is also new is the direct responsibility of a controller and a processor directly towards the data protection authorities. This is new today. Under European law, only the controller is directly responsible, and as you might see, I mean, many European companies have their cloud service provider in the US or in other countries of the world, and they are the so-called processors under the law, and they are facing like a new direct liability and responsibility towards the data protection authorities.
Volker, when you were talking earlier about applicability, we had a question come in. Does the GDPR apply to government agencies? What about the FBI or CIA? These intelligence agencies are not going to ask for consent from people they put under surveillance.
That's true, and I think I can give you the answer that it's about the material scope, and Article 2 says that those kind of public security agencies and so forth, they do not fall under this regulation. GDPR doesn't apply.
I also had another question come in about the applicability of GDPR generally to U.S.-based SaaS providers. And this is more specific. This question, the registrant asks, if a company collects basic information such as name and email address through its website without address information, how will the company know if the individual users are EU residents?
You might not really know it from the basic information that you receive, but I recommend, because the law says, or GDPR applies when you target and like a website would be then a service, EU citizens, that you implement GDPR requirements, because what data protection authority are going to do, they're going to try to find whether you use, for instance, apart from the English language, also other European languages that prove that you directly address, for instance, French people or Spanish people or also German people, and on top with, for instance, shipping information that you really target and offer goods and services to EU citizens, then it's like a strong indicator and kind of a proof that GDPR would apply. So I recommend, if you really want to address EU citizens and data subjects, and you would say also when you have an audit of your website, it's better to comply with GDPR. But maybe another word, GDPR is also kind of risk-based. So if you can also take measures and make clear that which is your target audience, or what is your consumer that you target, and make it clear on your website, that would be also a risk-based approach to make clear that you do not really want and do not fall under GDPR. But these are really, they're new articles, and you have to find a way in practice how to cope with them. Okay.
Okay.
So next slide is about what is personal data under the GDPR, and I think this is also something which is not totally new, but which gives also or puts the finger on the difference between European idea of personal data and the idea of personal data in other parts of the world. We have a clear definition in the GDPR in Article 4, any information relating to identified or identifiable natural person, and also the last question that we had, it's already enough that you have a name or a first name in order the GDPR would apply. It's not that you need those kind of secondly the special categories of personal data, so that you need to talk about like health data or like another way sensitive personal data, but of course GDPR also applies to those kind of personal data, and especially also, which is new also for Europe, it's here also says it's about biometric data, and also data of your location. So GPS data might also fall under GDPR. And I think this is a big difference to the idea of personal data like PII, for instance, in the US, and that's we have to keep in mind.
Yes, that is true. In the United States, the statutes that dictate, data breach notification, for example, often provide lists of very specific types of data, like name plus social security number or financial account number and access code, for example. We have about 8 slides and about half an hour left for our timing, just to keep on pace.
We go on. Just a short overview on like the roles that you should differentiate under GDPR. There's the data controller, which is a natural or legal person, public authority, or other body, which alone or jointly with others determines the purpose and means of processing personal data. So this is the important part. The one who determines the purposes and means of processing personal data is a so-called data controller, and this role, first and foremost, already today is the one who is liable for any breach of the data processing, which is new then, as I said, the data processor also, which is the person who processes the data on behalf of the controller. So as Stephanie said, for instance, the software as a service provider, cloud provider, those are the regular data processor roles. They are in the future, not today, but from May 2018 onwards, they can also be liable for data in compliance, and which is the subject is the data subject, every natural person to whom the personal data relates. And as I said, it's not only EU citizens that there's no definition on EU citizens, but you can have also another nationality to be regarded as a data subject under GDPR. Well, of course, I mean, you can, the question, no? You ask, can a company be both a data controller and a processor? I mean, you can get in different roles. I mean, you can, for instance, and that's what we usually have in group companies. I mean, we have a parent company and then subsidiaries that you by yourself are a data controller and you process the personal data of your employees. But then, for instance, when you're the like IT subsidiary, you are a data processor for all the other group companies. And then you are in the role of a data processor. And what is important in this relationship, and please always keep in mind, also the new law, this GDPR, doesn't regulate any like group privilege, we call it. So every like legal entity has its own responsibility, and you're basically not allowed to share and forward and process personal data in a group, like sending it to the mother company, to subsidiaries, and so forth. You always need a legal ground for these kind of data processing. Yeah, very good question there. And we go to the next one. Will indemnity agreements work to shift all responsibility from the data controller to the data processor? Are you insurance firms coming up with ways to provide them with coverage? I mean, we see a lot of movement in insurance products concerning IT security and compliance with data protection laws. I'm sorry, I can't give an overview on those now, but I mean the agreements could be, of course, a recommendation to put into your agreements between data processor and controller clauses that cover these worst case scenarios, but you could never move like the responsibility from you with these clauses towards the data protection authorities. It's just an inner agreement issue to have these liability clauses. Information is not, before we go on, because I think we have to go on a little bit faster. Information, here's the question: is it defined under the directive? Does it include any information that the processor creates in relation to the subject? Well, information is not is the broad word which is really not useful when you try to think about the application of the law, because you always need this personal data, and information can be any data, and therefore it's not defined in the directive or in the regulation. It's important. It's a regulation. Yeah. So going forward with the rules under GDPR, as I said, very new for many EU member states. Not so new because I understood there are many DPOs also worldwide. Maybe they are there for another good reason, but the data protection officer is implemented in the German data protection law since ever. It continues with a very special regulation with the 10th employee that you have, but nobody else, as far as I know, in the EU has this requirement with a number of employees. But you need to have a special approach of monitoring personal data and work with sensitive personal data to be obliged to have a DPO. The message here is to you that because I know these discussions with very small companies or startup companies, they see this. I mean, from the German perspective now, this requirement with the 10th employee, I need the formal role of a DPO, and if they do not reach the number of employees, they don't care about data protection at all, and that would be a misunderstanding of the law. This is also here in the GDPR a formal requirement, but nevertheless, when you do not need a DPO as a formal requirement, you of course have to follow and comply with the data protection law itself. So there's always the need for somebody in your company or as a service provider, an external consultant to help you with covering these requirements. The Data Protection Authority is of course the one that you should always keep in mind, that they are the ones that can execute the fines of 20 million or 4% of the turnover. Today is not that high, as I said, but we're going to see what happens in the future. And the EU representative, as I said, is regulated in Article 27. It's an important role that you need either as a controller or processor when you're not established in the EU, that you designate by written mandate a representative to act on your behalf and cooperate with DPAs to ensure compliance. And that's one important aspect that I already mentioned. And I think now we come to very important GDPR requirements that I think some of them are, or people might be very familiar with around the world. Just to pick in my opinion, the most important ones are the number 2, data breach notification, and number 5, DPIA, the data protection impact assessment. I think these are concepts that are not really new for most parts of the world, and I know there are a lot of breach notification laws in the US as well. Beginning maybe with this one, because I already mentioned the importance or not importance of consent. Because saying that maybe in 2 or 3 words, consent is really only necessary when you do a lot of, for instance, email marketing, that you're really aware of the data and the source where you received addresses from, and whether they needed a so-called opt-in, which is consent, like an active consent that you want that, for instance, email being used as a marketing email, and other requirements of consent are, for instance, in an employment relationship, very difficult to fulfill because it has to be freely given. I mean, you can't really urge your employee to give you consent, then it's not a valid consent. And you need to specifically inform and give an unambiguous indication of the data subject's use of the personal data. So consent is important, but not like very important for every aspect of your business. So, and there's a question
on consent. We have a question directly related to consent. Yes.
Yeah.
Can EU users agree or acknowledge to waive GDPR compliance? For example, can they waive their right to consent?
Not really. I mean, you can't waive your GDPR rights, but of course you can. And that's my my recommendation. As a business, you should think about other legal grounds to do your business rather than consent. And there are many valid legal grounds for data processing of personal data. For instance, the fulfillment of a contract. Yeah, of course, there you need to process personal data. And that's, I think, a little bit the misunderstanding of the concept of consent. People who hear consent think, do I need now to write and ask every employee, every customer I have about consent on the processing of their personal data? Of course not, because towards your employees, there's the requirement of necessity. You need personal data for the fulfillment of the execution of the employment contract, and of course you need personal data of your customers to send them products, to give them services, and there are only few aspects where you should rely on consent. Also, because you always have to keep in mind that consent can be withdrawn and then the legal ground is gone. So my recommendation, do not put too much effort on consent and try to put your business on other legal grounds. So again, coming back to the breach notification requirement, which, as I said, is not new, but which is really tough to fulfill, is the 27 hours time period, where the law says that you need to notify not later than 72 hours after having become aware of the data breach, the data protection authorities. And this is, of course, not really an easy task. What I always want to underline, that it's important that you at least give the supervisory authority or the data protection authority a reason for the delay. If you're not able to present the necessary content, which is also written in Article 33, in between these 72 hours. So it's always recommended to communicate with the authorities rather than to wait for a long time and then being facing a fine for non-compliance with this 72 hours. And what you need to then report is the nature of the personal data breach, give the name and contact details of the DPO, and describe the likely consequences of the personal data breach. And the fourth aspect is that you should try to describe the measures that you take to address the personal data breach. And I'm sure, which is important, of course, to set up a guideline, or that employees and your service provider support these very fast notification duties to you, as you have the duty to report. And it's also important, never forget, you should, before you report, check whether it's really a data breach that needs to be notified, because an important requirement is that the data breach has to be likely to result in a high risk, or in a risk to the rights and freedoms of natural persons. And then, of course, the question is what is a high risk, and there the idea of harmonization comes into place. For the data breach notification article, has been published a so-called a working paper of the Data Protection Working Party, Article 29, and it's the Working Party paper 250. When you put it into Google, you're going to find that paper, and also in English language, VP 250 on data breach notification. There are examples for these risk to the rights and freedoms of the data subject. So you can have a basic understanding on when it applies and when it's not the case. Which is also important when you made that notification, the data protection authorities are not really allowed to fine you for this data breach itself. They would only fine you for not making the notification in time, but the aspects that you report and the data breach itself cannot be fined then directly by the authority. So don't be afraid to maybe report when it's really necessary. And I mean the aspects here, right to access, right to be forgotten, data portability are results from or parts of them of strong lobbying of consumer protection rights NGOs and organizations. Right to access and right to be forgotten in a way is not new, but they really address our so-called erasure law, like search engines like Google or social media platforms, and give like consumers a clearer right to have some personal data being erased that harm them or that really do not comply with the law, but which is important to understand, because many companies think now, okay, when there's an employee or a consumer or customer that wants me to erase personal data, this can be in conflict with other laws, and of course this can be in conflict with other laws, and so these consumer rights only go as far as you do not violate, for instance, all the laws for archiving and documentation of business processes in tax laws worldwide. I mean, you have to present somehow what you did during the business year, and present also personal data doing that, and they always remain, and so this can also stop consumers from executing of their right to be forgotten. Data portability is more like a competition law aspect, addressing social media channels, and but it's a strong right. I mean, you have to present in a way a format that you can move data from one place to the other, and that in practice we have big question marks on how that is going to work. It reminds a little bit on like mobile service providers, cellular phone companies, that you enforce competition when you when you remain your telephone number when it stays with you when you move to another service provider, and that's the idea also behind the data portability right, that the law tries to encourage people from moving from one network to the other and being able to take their personal data with them. But in practice is really a big question mark on how that's going to work. What is also important, data protection impact assessment. Together, I think, with breach notification these two requirements really can put you into contact with the data protection authorities. Please keep those requirements in mind. They are really important because the so-called PIA or DPIA, as we already know it, is like the requirement of making an assessment like internally first when you have a high risk data processing, and you need to consult prior to the implementation of that data processing the data protection authority. So and this again has the notion of risk, but here it's high risk. And again, I would like to recommend you to read one of these papers that follow the idea of harmonization in the EU, because it's a paper that all the European authorities work together in, and it's called VP 248, Working Paper 248, and it's a guideline that gives practical ideas on when you could think about like high risk data processings. And to give you just two examples, it's about when you process sensitive data and when you do monitoring, for instance, with CCTV cameras. Yeah, I spoke about the DPO already.
Volker, we do have, we have a couple of questions that I think can be answered rather quickly on the data breach notification.
Yes, please.
The first is how big should a data breach be so the GDPR notification requirement would apply?
The data breach, it's already
I don't think there is a number.
Applicable when it's already when there's a risk for the data subject. And again, I recommend Working Paper 250 with examples.
Okay. I think the question
there's
was
not a number,
how many. Yeah, there's no number. It could be just one person, and you have whose information has been exposed, and that would constitute a data breach that would require notification. Correct?
That's correct.
Okay. There's another question here about the data breach notification law, noting that it's very common that companies don't have a lot of information within 72 hours of a data breach, but they know that there has been a breach. How do they comply with that short 72-hour notice rule?
Yeah, it's really, you can cite the law here, Article 33. Number 1, it says where the notification to the authority is not made within 72 hours, it shall be accompanied by reasons for the delay. So that's what I meant with please contact the authorities and give reasons why you're not ready to report full.
Okay. On the notification, can you cover just very clearly the timing requirement for a sub-processor or processor and the timing requirement for a controller?
You have to organize yourself. Yeah. I mean, the one that is responsible, which is basically today the controller, in the future or the processor, has to organize it with contracts, agreements, and everything. And it's also like an obligatory aspect in the so-called Commission Data Processing Contracts, Article 28. To talk about the process of data breach notification. So your processors, of course, need to support and directly notify you as a controller on a data breach, so that you can that puts you into the position to check whether it's really something that you have to notify or not. And you should, of course, also prevent with these contracts and these clauses your processor to directly report to the authority, because he or she the company could have a different view on the responsibilities of the breach. So organize it with the right contracts and guidelines in your company for reporting from your employees.
Thank you, Volker.
I think we have to move on.
Yes.
Yes. move on a little bit faster. And I think, as you said, we're going to provide you with the slides, because at the end we have a 5-step plan for GDPR readiness. What's next? So we recommend, of course, a high-level audit. What data do you have? Where is it, and where does it go? Do you have transported data flow? When did you acquire it? So think about the source. When it's about a consent issue, why do you process it? So think about the purpose. The legal grounds is very important, and as I said, there are many legal grounds, but you need to document those legal grounds. Next step would be an action plan, which should be important here in brackets, risk-based approach. You should, after identifying your gaps, make a risk-based approach. How is the likeliness for the occurrence of that risk? Is there a high fine behind this breach, or is it more about your reputation towards end customers? So set timelines and give responsibilities in your team. Thirdly, third-party compliance. That's what I meant with Article 28. Work on the contract side. Work with joint controller and processor to agree upon rules and guidelines for handling of personal data. There are very strict but precise requirements in Article 28. What do you need to have in those contracts? And we can help you with this, of course. Modify contracts as needed, and the policies as well that you need in your company, for the internal process, because when your employees do not support the idea of GDPR, you're in a difficult position. Why we also recommend training, awareness training for employees. When you have a bigger organization, of course, e-learning and something like we do now, use a webinar and reach out. Document that you reached out, because it's also an aspect that you need for this most important principle called accountability. And last one is review and assess. GDPR requires ongoing review and verification of effectiveness of measures used to protect personal data. So that's basically the 5-step plan, and I hope you gonna see the necessity to work on GDPR, and hope I could give you a short overview on the requirements and how to handle it in practice.
Thank you so much, Volker. We are now at 10:59, and this webinar is over, but we will be presenting it again for those who joined in late or had troubles with audio. We're going to represent this program in about 1 minute. I'd like to thank you, Dr. Volker Wodianka, for sharing your time and expertise on the GDPR today. I also want to thank Mackrell International and all of our colleagues in the Privacy and Data Security Group who are supporting this 3-part webinar series. If you have any questions, or if you know of others who would like to register for the December 7th and the January 23rd webinars, where our Mackrell colleagues will be going into more detail about the GDPR, please email gdpr@hoegfenton.com. That is also the email address for those of you who want CLE certificates. Please email gdpr@hoegfenton.com. This concludes our program for 10 o'clock. Have a great week, everyone.